Good afternoon, everybody, and welcome to the Law and Crime Network. I'm Jesse Weber. Thanks for joining us. We are playing replays right now in the Holly Bobo case. And why are we doing that? Because last week there was a status hearing regarding that case. John Dylan Adams, who's another one of the perpetrators of this horrific crime of 20-year-old Holly Bobo, a nursing student from Tennessee. Her remains were found about almost 3 years later when she disappeared from her house. We saw back in September, Zachary Adams was on trial. He was found guilty in connection with her disappearance, murder, rape, kidnapping. It was a really horrific series of events that were described in that case. Well, now his brother, John Dylan Adams, will be on trial. And as we heard in a status hearing last week, he is going to be on trial looking around May 29th. So we're replaying some clips today of the former case, trying to understand what we can anticipate in that case. And a little later on today, we're going to be having Burton Staggs on, who's the news director for WOPC HD News. Now, that is a radio station near where this trial is going to take place, and he can give us some in-depth analysis and kind of an insight into the community for that case. So you're not going to want to miss that. But I do have to preview for you another case that we're covering here on the Law and Crime Network, a case that we're going to expect opening arguments in tomorrow. This is a case out of Florida, another case out of Florida. This is the case of a really terrible nightclub shooting out of Florida. Laquan Brown, Gary King, and Michael Smith are each charged with one count of second-degree murder for the death of 19-year-old Benetria Robinson in 2015 in a nightclub shooting. The nightclub is called Cloud 9. And Barrow and Smith are also charged with 5 counts of attempted second-degree murder, and King is charged with 4 counts of attempted second-degree murder. So again, there was one fatality, but multiple people were injured in this shooting. We're going to be covering it tomorrow. We expect opening arguments. This trial is really going to be very interesting when you hear the eyewitnesses to this fight that took place inside a nightclub, made its way outside of a nightclub, shots were fired, and from all accounts, and as the police have described, this young woman, a 19-year-old, who was just minding her business and wanted to have a good night out, she died. So it's really tragic, and we're going to have to cover it here and really break down every single aspect of this case and what these three defendants are faced with. So tomorrow, we do have opening statements in that case. We're going to be covering it here on the Law and Crime Network. Now, having said all that, we do have some special segments for you today, some updates in really important cases, and one of them is Making a Murderer. Now, Making a Murderer, this is the huge Netflix series. I'm sure many of you watched it out there. This is the case of Stephen Avery, who was sentenced along with his nephew, Brendan Dassey. He was sentenced to life in prison for the 2005 murder of Teresa Halbach, a 25-year-old photographer. But now, there is an update in that case, and who better to talk about this case with than our resident expert, than the man who covered this case when it was taking place, Aaron Keller. Aaron, good to see you.
Good to see you, Jesse. What's going on?
So let's talk a little bit about what's happening so far. We know that Mr. Avery has had a development in this case in the past few days. Please share with our viewers what's going on.
Well, it came out recently, and here's the thing. We juggle so many trials here that I don't always get a chance to dig straight into every single one of these documents the second that they're filed. But his attorney, Kathleen Zellner, his post-conviction attorney, has filed a second supplement to follow up a motion for reconsideration, which she previously filed. Basically, it's yet another document in a string of documents seeking to get Stephen Avery a new trial. That's the most recent document that's been filed, and that's where we sit right now.
So basically, from what I've understood, she has new evidence that she's hoping to exonerate Mr. Avery, saying he had nothing to do with this crime, and the goal is to present this enough evidence to say he deserves a new trial. It's not so simple to get that, correct?
It's not a simple process to get a new trial, but ultimately, yes, that's the defendant's goal through his attorney, is to try to convince a judge that this evidence, which she is characterizing as new, should be enough to say, hey, look, Stephen Avery should get a new trial. Now, there are questions as to whether or not the evidence truly is new, because a lot of the evidence is there in the police reports and there in the record from the first trial. It's a question as to whether or not it's being characterized in new ways. There are some new affidavits that are being filed. Some of them are certainly more concerning to me than others, at least as somebody who's been covering the case since the day that the victim was reported missing. Some of it I don't personally think is as new as new evidence normally would be. For instance, the 1985 case, the famous case for which Stephen Avery was wrongfully convicted. Now, in that case, DNA technology became available while he was in prison. Some evidence was tested, and not only did it prove that he didn't commit the rape in 1985, but that another known criminal in the area did commit that rape. Now that's new evidence.
Because
the DNA report was new evidence.
His theory, for everybody who maybe hasn't followed as closely, is he's saying the police framed him. I mean, that was the whole theory behind the Making a Murderer case, that the police department in that county framed him for this crime. And
yeah,
now,
it was bad blood from the 1985
right.
case. So you got the 1985 rape case, you've got an exoneration, you've got a huge lawsuit filed against local officials for botching the first case, and it's well set up in the film as to exactly how they botched the 1985 case. It wasn't just that the DNA evidence wasn't available in 1985, at least the testing wasn't available. It's that other suspects weren't explored, that photo lineups were more suggestive than they should have been, and so a lot of bad blood between Stephen Avery, his family, and the local sheriff's department from the old case. Fast forward to 2005, you have a woman, Teresa Hallbuck, missing, and questions about what happened to her. One of her last appointments that day, in the state's version of the case, her last appointment was at the Avery family salvage yard. And where did she go from there? Did she leave the property or did she not? It's long been insinuated that maybe she did leave the property after that appointment. Kathleen Zellner, the post-conviction attorney, is trying to push forth evidence that she was not last seen by an independent witness walking towards Stephen Avery's trailer.
Now, isn't there also evidence that the bullet that they found didn't even have human remains on it, didn't even have a skull fragments, but it really had wood on it? Wouldn't that be huge? That they're saying that this bullet that was used to shoot her in the head doesn't even have it doesn't have human remains on it.
Well, that's one of the accusations that's floating out there, is that this bullet has wood on it and not human bone fragments. We're talking about very high-powered microscopes getting into that kind of an analysis. So that would be an example of some of the new evidence that's out there.
So let's talk a little bit about what their other strategy is. From what I've read, to take away the evidence that they might have to exonerate him, isn't he pointing the finger now at Brendan Dassey, his nephew? Isn't he pushing it even a little further, saying that there was new evidence discovered on Mr. Dassey's computer about what he was looking at?
Well, it's a question of which Dassey had the computer and who had access to it. And this is a situation that I started examining because some of the recent arguments, to me, need a little bit more factual development than what we have. There was a computer in the Dassey home, which was basically right next door to Stephen Avery's. It was on the same property. Questions about who had access to the computer, questions about exactly who was using the computer, because we know that there was pornography on the computer, and Kathleen Zellner is characterizing it as violent pornography.
Yeah, she's saying it's involving young females being raped and tortured, images of injuries to females, including decapitated heads, bloody torsos, bloody head injuries, and mutilated bodies. She's saying that this was found on Mr. Dassey's
it's
computer.
Disgusting stuff.
Yeah.
I mean, there's been another forensic examination of this computer based on data that was dumped off of it back in 2005, 2006. Well, it was seized in 2006. So, you know, part of what's going on here, though, is a question of, okay, well, who had access to the computer? And I wrote a piece with a number of what-ifs in it, which resulted in some criticism of me. But the most recent filing that Kathleen Zellner has put forward basically seeks to rebut a story that I've got up on lawandcrime.com, because we've got the computer out there. Well, you know, there's a lot of back and forth. Okay, well, whose bedroom was it in? Well, Bobby Dassey, one of the other nephews, she says it was in his bedroom, but then one of the other relatives said in one of the early reports it was in somebody else's bedroom. And it's a question of, okay, well, who had access to the house? Did Stephen Avery himself have access to the house? I raised that question, which then Kathleen Zellner rebutted in the most recent filing with what is not really a blanket denial of access to the computer, but he says, well, I wasn't around for most of the searches of it, and the way that it's worded theoretically leaves some possibility open that Stephen Avery could have been involved in at least some of the searches. But as I pointed out in the original piece, could not have been involved for all of the searches.
Right.
So there's a lot of characterizing of evidence, and look, questions as to whether or not police even started getting interested in these searches on the computer. How did they get interested in the computer in the first place? And that's another what if that there are a couple of explanations for.
Aaron, there's also, I see that he's also saying that, or at least that it's coming out from his attorney, that his attorneys that were representing him at the time are claiming that they were ineffective, that they didn't do a good enough job for him at the time. I mean, what did you see about that as well?
There's an accusation and there's an
That's
affidavit.
big. That's usually a big thing when people are trying to get a new trial or trying to reverse their conviction. The attorneys coming out and said I was ineffective.
They didn't flat out say that they were ineffective.
I'm talking about Dean Strange.
Yeah, Dean Strange didn't. From what I remember from his affidavit, he didn't come flat out and say he was ineffective. Zellner said he was ineffective and backed it up with an affidavit from Strang in which Strang said, I made these strategic decisions and they were mine alone. Okay, so then she kind of characterized that as she said, well, he more or less, well, she didn't put it that way. She claimed that he admitted he was ineffective. I don't think that he per se use that word, but that's the direction she's trying to take the argument.
Now, before I want to just briefly talk about what's going to go on with Brendan Dassey, but before we move on to Brendan Dassey, real quick on Stephen Avery, in your opinion, with this latest development, what do you think is going to happen to him in 2018? What do you think we're going to see from him? Do you think that he might get the possibility of a new trial?
It's a long shot. I don't honestly know if I can predict that. And if I've got a strong feeling one way or the other here on Law and Crime, I oftentimes say so. It's going to take, well, let me back up. First of all, you've got more than 1,000 pages of documents that have been put on the lap of a local trial judge in a relatively small county in northeastern Wisconsin. If I were to guess, I'd say it's probably a judge with one clerk. The volume of information that's hitting this judge, it's not the judge that handled the original case, is just, it's a deluge. And so, does the local judge have the resources to dig into this as much as possible? What's the state doing to rebut it? We haven't heard much of anything from the state. Keep in mind, it's the Attorney General's office that has the case now. So we don't know exactly how the state's going to respond to some of it. We don't know if all of the purported new evidence is going to hold up in court as new evidence.
There's a lot of factors.
Some of it's really concerning. And look, I've said from the beginning, from 2005, when I was a local reporter up there, that things revolving around
your hair wasn't less gray. It was the same gray. So nothing's changed.
It was less gray. It was somewhere between what it is now and yours. Okay, so, but look, I said back at the time, there were problems with this police investigation. And as we get more and more access to the record, we see more and more and more and more problems just piling up. What does that mean? Does it mean that police got the wrong guy, or does it mean that the investigation was just not done terribly well?
So speaking of the wrong guy, before we close out this segment, real quick, I want to talk about Brendan Dassey, constantly in the news this past year because the U.S. Court of Appeals for the 7th Circuit is now deciding whether or not that confession, ladies and gentlemen, that you see, that confession tape you see, we're replaying for you right now, whether or not his confession was voluntary, was it coerced. They are now deciding that, and this panel is now going to be deciding it. Do you expect a decision from them before the end of the year? And if so, what do you think we're going to see from them?
Again, impossible. Excuse me, I've been on the air so long I'm losing my voice already.
It's
impossible to predict when that decision is going to come down. I'm anxiously awaiting that one as well. I have a lot of respect for the two attorneys who are representing Brendan Dassey, Steve Drizzen and Laura Nyrider. The correspondence that I have had with them has been brief, but they have been very professional in the way that they've handled the case. Their arguments have been good. They are representing Brendan Dassey very, very well. I'm anxious to see how the 7th Circuit comes down on this. This is one of the cases that I've covered that just has so many fact issues and law issues. The thing that I've been harping on since the beginning of this is that the law has set up a process that leaves a lot of people, including myself, uncomfortable with the way that these things rolled out. And the questions of the process are independent from the questions as to whether or not these two were involved or committed a crime. Even if they did commit the crime, and notice I said even, I'm still uncomfortable with some of the process that rolled out here. And
I 100% agree with you.
And we've got states like California that have recently taken this step. I don't think it was a direct result of this case, but they've taken the step to say, hey, no interrogations of juveniles without an attorney present. The right is not waivable. In other words, the police can't call someone young in and say, oh, by the way, you've got a right to an attorney. Will you waive it? Well, I mean, how is somebody who's 10 or 12 or 15 years old going to respond to that or understand the full implications of it?
Aaron, you don't even need a legal degree to see that tape right there. There was something wrong. There was something wrong, whichever way you take it. And I 100% agree with you on that. That the procedure of it, there's something off.
Yeah, procedurally, there are issues attached to it. I'm more comfortable with a system that says it's an unwaivable right. I think California is onto something here, and I'd like to see more states follow suit. But in the absence of that, how do we characterize that recording? The state and the jury which convicted Brendan Dassey characterized that as an attempt to lie out of a situation, and in that attempt, he fabricated a couple of things, but ultimately there was a grain of truth in it. And that's how the jury that was seated in that courthouse took that so-called confession. The jury's demeanor changed drastically after it saw parts of that recording. And at that point, the jury just didn't want to buy what the defense was selling.
Sure.
Now, again, how do we deal with that legally? Should we set up a system that says, no, we're not even going to let it get to the jury if there's a problem with the process? In other words, make it a question of law.
Right.
No attorney present, it gets thrown out. It's like the exclusionary rule of evidence.
You know, what's interesting is we are going to be waiting for a decision there, and then the question becomes, whatever the decision is, will this be taken up to the Supreme Court, who doesn't have an obligation to hear it, but will they hear it? And it's going to be very interesting to see what happens in that case. So again, we always are covering the Making a Murderer case here, and our resident expert, Aaron Keller, will always be here to talk about it.
I am always reading something attached to that case, even if we don't see a report on lawandcrime.com. Sometimes I see things and they don't jive with my memory. Sometimes I see leaps taken logically. You know, it's a case that we'll probably be debating for the next 100 years.
Hopefully we do have some more answers in the new year about that case, and again, what will happen to Mr. Dassey and what will happen to Mr. Avery. But in the meantime, when we come back from showing, we're going to be continuing showing you Holly Bobo, the replay of that Zachary Adams case in anticipation of the John Dylan Adams case, which will begin in May. We heard a status hearing from that case last week where it was decided when that case will be heard, so we're previewing some of the